Committee on State Affairs will come to order. Will the clerk call the roll?
Betancourt, Birdwell, Hall, Hinojosa, Middleton, Parker, Perry, Shortner, Saffarini, Paxton, Hughes.
Good morning. The chair lays out. There it is. Thank you. The one that says Sponsor King. House Bill 1506 by Representative Ashby, sponsored by Senator King, and recognize and welcome the sponsor to explain the measure. Good morning.
Thank you, Mr. Chairman. It's hard to get a committee together with education laying out HB2, and which is where I need to head, and then B&C meeting too, and everybody else. So this is a very simple bill by Representative Ashby. Under current law, the expedited process in which a county or district judge can apply for an expedited license to carry only applies to judges currently serving in those roles, while retired, visiting, federal, or senior judges are permitted to apply for an expedited license to carry. Retired county and district judges are not eligible. HB 1506 would allow a retired county or district judge to apply to the Department of Public Safety for an expedited license to carry permit if the retired judge served at least 48 months on the bench. Be happy to answer any questions.
Thank you, Senator King. We'll open public testimony on House Bill 1506. No witnesses have registered to testify on, for, or against, so we'll ask, is anyone present wishing to testify on, for, or against House Bill 1506? Seeing and hearing none, public testimony is closed. Bill's left pending at this time.
Thank you. I'm sure this bill will change life as we know it. So,
thank you, Senator.
Thank you. Yes, sir.
The chair lays out House Bill 4285 by Representative McQueen, sponsored by Senator Parker, and recognizes our colleague Senator King on behalf of the sponsor.
Thank you, Mr. Chairman. Happy to lay this out on behalf of Senator Parker. House Bill 4285 updates a narrow section of the Alcohol Beverage Code to reflect the operational needs of today's airline industry and supports Texas's position as a leader in air travel. Currently, airlines operating in Texas are allowed to store sealed alcoholic beverages at airports they regularly serve, provided they hold a passenger transportation permit. However, the demands of modern airline logistics, particularly related to food and beverage services, have outgrown the limited storage capacity available on airport premises. As a result, airlines and their authorized third-party logistics providers offer lease warehouse space near airports to manage provisioning needs. House Bill 4285 makes a simple update to allow airlines with a passenger transportation permit to store sealed alcoholic beverages either on airport property, as current law allows, or within 5 miles of the airport and within the same county. This adjustment supports operational efficiency without expanding alcohol privileges or weakening oversight. The bill does not create new alcohol permits, does not change who airlines must purchase alcohol from, and does not impact alcohol taxation. By making this update, Texas ensures its regulatory framework keeps pace with operational realities while continuing to safeguard public oversight. House Bill 4285 strengthens the ability of airlines to meet growing demands and helps maintain Texas's leadership in domestic and international air travel. I respectfully ask on behalf of Senator Parker for your support.
Thank you, Senator King. We're going to open public testimony on House Bill 4285 and ask if there's anyone present wishing to testify. Thank you, Senator King. Chairman King. Is there anyone wishing to testify on, for, or against House Bill 4285? Seeing and hearing none, public testimony is closed. Bill's left pending at this time. The chair lays out House Bill 201 by Representative Perez and recognizes its sponsor, the Dean of the Senate, to explain the measure.
Thank you, Mr. Chairman. Mr. Chairman and members, House Bill 201 by Representative Marianne Bettis relates to the Financial Crimes Intelligence Center. It's a companion to my Senate Bill 2028 and is a follow-up to House Bill 2106, which in 2021 authorized the Texas Department of Licensing and Regulation to prevent card skimmer installations at gas pumps and established the Financial Crimes Intelligence Center to coordinate related law enforcement efforts. Now we are seeing pulsar manipulation devices at gas pumps, which criminals install to manipulate the counter in the pump so it no longer measures accurately how much fuel is being dispensed. This is essentially stealing fuel from the pump, hurting small businesses and depriving the state of tax revenue. Generally then, House Bill 201 would expand the scope to include responding to motor fuel theft and directed to assist law enforcement or other governmental agencies regarding matters within its expertise. And that's all it is.
Thank you, Dean. Any questions for the Dean on House Bill 201? Open testimony, the chair calls Adam Colby. Charlotte Melder. Good morning. Good to have you. We'll ask each of you to introduce yourselves, tell us who you're with, and we'll have a couple of questions for you. Go ahead, Charlotte.
So, I don't know if these are on. Charlotte Melder,
Oh, you did?
with the Texas Department
There's
of Licensing and Regulation.
There you go. One more time.
Charlotte Melder with the Texas Department of Licensing and Regulation.
Adam Colby, Director, Texas Financial Crimes Intelligence Center.
Great to have you both here. Adam, thankful for the work you're doing. Give us a little update on what's happening, the resources you have, and how the work is going at the Financial Crime Center. Not all that new, but a relatively new thing that folks are becoming familiar with. We're proud of your work, and give us a little update on what's happening.
So, Mr. Chairman, thank you for the opportunity to address you. So the FCIC started October of 21 with 3 people. We're currently authorized 16. We have 15 of those FTEs filled. We started tracking our stats and started watching the types of crimes that we were dealing with. We had thought initially it was going to be nothing more than gas pump skimming for the first 2 years, but within just a few weeks, it transitioned into many other types of organized financial crime. Probably about 85–90% of what we deal with is transnational foreign criminal groups. During the last few years, while our border was fairly porous, it just got worse, and we had almost a 900% increase in some of these crimes. In this bill, specifically when we're talking about fuel theft, the same people that were doing gas pump skimming found another way to steal fuel. Gas pump skimming has evolved into basically a means to steal fuel and then resell it out on the black market. So these devices that we're talking about here are doing basically the same thing. Instead of stealing card numbers, it's tricking the pump into simply dispensing fuel for pennies on the dollar. As far as the FCIC goes, at this point, 3.5 years in, we can show that we have intercepted almost $350 million worth of fraud within the state of Texas.
Pretty good.
Outstanding, outstanding. Dean, any questions for either of our resource witnesses? Senator Hall, any questions for our resource witnesses? Thank you for being here. Thanks for what you're doing.
Good work.
Sir.
Thank you.
We'll open public testimony on House Bill 201 and ask if there's anyone wishing to testify on, for, or against House Bill 201. Seeing and hearing none, public testimony is closed. Bill's left pending at this time.
Thank you. $39.09.
The chair lays out House Bill 3909, 3909, Representative Hicklin's bill, sponsored by the Dean of the Senate, and the Dean is recognized.
Thank you, Mr. Chairman. Mr. Chairman and members, House Bill 3909 clearly is a bipartisan bill. It was authored by Representatives Hillary Hicklin, Aaron Zwiener, Daniel Alders, and Lauren Ashley Simmons, as well as Paul Dyson. So it's pretty bipartisan, and relates to the use of a wireless communication device at a polling place. Members, current law prohibits the use of wireless communication devices within 100 feet of voting stations. At many polling locations, however, this effectively bans people from using their phones while waiting in line outside to vote, and sometimes that can be hours. An unnecessary restriction that is difficult and time-consuming for election workers to enforce. Generally then, House Bill 3909 would limit the prohibition on wireless communication devices to only the room in which voting is taking place.
Any questions for the Dean on House Bill 3909? Very well, we'll open public testimony, and the chair calls Dr. Laura Presley. Dr. Presley is the only witness at this time that is registered to testify on, for, or against House Bill 3909. If there's anyone else wishing to testify on, for, or against House Bill 3909, please make your way down to the table so we can get you set up to hear from. Dr. Presley, welcome. Introduce yourself. Give us your testimony.
Hello, Senator Hughes and committee members. I'm Dr. Laura Presley, and I'm here to speak against this bill. This bill is actually a technology bill because it has to do with removing the 100-foot limit that wireless devices, let's say Bluetooth devices, can be close to the polls and close to our voting systems. I'm handing out to you, and I love page 2, which is a really great picture. Imagine the guy here sitting in a computer, and there being guards around the computer, because this is really what we have in our voting locations. Bluetooth devices were designed to transfer large data files over a short distance, and to remove this 100-foot limit is very dangerous with regard to what can be now close to these systems within that 100 feet. What I've given you is, there's a page on page 3. This is from the Bluetooth range estimator, given different parameters of the Bluetooth device and what distance they can download files. It is amazing. The 100-foot was actually put in place in 2007, 2003, I think is when it's first, I think I have it on page 1. 2007, this law was instituted. It was not for just electioneering. It was from a technology standpoint. Bluetooth came into play in 1998. It's been around a long, long time. I want to show you on last page 4, which is very important for you to see this. This is an image taken by a Travis County election clerk, and it shows the Bluetooth is on our poll books. So if you allow Bluetooth within that 100-foot distance, you can now have rogue and bad actors downloading data. So this is a technology bill. If you don't want to believe what I'm saying and you're not looking at the data that I'm providing you, I would say table this bill until you bring some technical people in here to discuss this. It looks like it's a simple bill, get rid of the 100-foot limit. It is way more serious than that. I think this is the worst election bill of the session. It has the most potential for danger and problems from bad actors. So,
Well, thanks for your testimony.
Any questions?
If there's any questions, Dr. Presley. Senator Hall, you're recognized. Oh, I'm sorry. I thought.
It's my bill.
Did you have your light on, Dean? Okay, go ahead, Senator Hall.
I think what we have here is we refer to this all the time as unintended consequences.
yes, sir.
We have a problem with people, as the dean laid out, having to stand in line for a very long time outside the polling location and cannot use their telephones.
Right.
And I don't disagree with that. I've been one of them, and so I know what that is like, and that is definitely a problem. But I also recognize the technology issue.
That's right.
And we know that our poll books have been accessed, messed with, and changed. It's not speculation. We have hard evidence. We have videos. We have recordings of the poll books being manipulated at our polling locations.
That's right.
So we know they have a problem. And so I don't know how we solve this problem of folks that it's a legitimate problem that they're talking about without introducing the unintended consequences of people being able to, now, the other side of this, those things that can do that, that can be in their pocket and you never even know they have them. And so it's, the other side of that is not the person, you know, there with the phone up to their ear.
Right.
It's the problem. It's the person that has that phone that's in their pocket. And they don't touch it. They just walk in. And so you bring up a problem we have with our electronic poll books.
That's exactly right.
That we
Yes, sir.
need to recognize, have a solution for that. And so we're kind of caught in between here. And until we do that, I have a problem opening up any opportunity for people to more easily be able to manipulate our poll books in doing it until we can find a solution. And there is a good solution. It's called paper poll books that work real well.
love that
They
idea.
are really not susceptible to electronic manipulation.
That's right. That's right.
Like they
You know,
are.
and
So I'm truly concerned that we're opening the door here unintentionally, and I'd be open to any discussions of how we solve this problem of folks having to stand in line and not having access to their phone, particularly folks have to leave their kids at home and things like that. Yes, we do need to solve that problem, but we don't need to make our electronic systems any more, or our election systems any more vulnerable than we've already made them.
That makes sense. Dean, did you have your light on?
No, I'm just in presenting the bill.
Oh, very good, very good. Thank you. I think your mic may still be on. Okay, got it. Senator Paxton, you're recognized.
Thank you, Mr. Chairman. Good to see you.
Good to see you.
So the picture that you showed of the Bluetooth being enabled on the last page of
Yes,
what
yes,
you
yes.
brought for us, so that's, whose screen is that?
That's a screen from a Travis County election worker, and he was concerned when he saw this. So he sent this to me, and I've redacted out the IP address. He was a little concerned about that, but actually, even in Williamson County where I vote, the poll books have the Bluetooth turned on to communicate with the card printer, the activation card printer.
Well,
Yes.
that was where I was going with this.
What's it talking to?
Is it
Yeah.
necessary for that? So the screen that you showed us, that was the poll book?
Poll book.
Okay, and the Bluetooth is enabled on
Yes.
that screen that we saw a picture of. It's enabled because it's necessary for it to communicate with what?
The activation card printer. So the poll book checks in the voter, and it prints to a printer that Senator Paxton is 6 inches away from the computer. So I just don't really understand why there's not a wire connection. Why do you need a Bluetooth connection that has a 100-foot radius when you're just sitting right next to this? Here's your computer, and here's the printer.
Is that always the case, that it's right next to them?
Yes. Yes, so it's really, from my standpoint, I'm like, why are we using this massive technology for this little printer that's sitting less than a foot away? I have some concerns about that, and there's a lot, and we can table the discussion that the machines have, the voting systems actually have wireless connections that they could be connected to. This doesn't help that argument. So especially when this thing's only a foot away.
So I appreciate what Senator Hall said about the unintended consequences sometimes that happen. This is trying to solve a legitimate problem, and that seems like that could potentially be a solution. If it is always the case that the printer is right next to that electronic device that needs to communicate with it, that might be one way of adjusting this. So,
Yeah.
Thank you. Senator Hall, you're recognized.
I'd maybe a possible solution that move us a bit forward here, because we have a problem with the electronic poll books. They're always connected to the internet. They always have Bluetooth, and both of those are easily manipulated, accessed improperly. One step might be to consider allowing this to happen in a location in which the poll books are hardwired to the printer. That way you could allow this. It'd be an encouragement for people to actually make the systems more secure. I would think that an amendment to this bill might fit. I haven't looked at it, but that to me would be a solution that allow this to happen in those locations in which the election crew setup has the poll book hardwired to the equipment in there, as opposed and Bluetooth turned off.
You know,
And
the situation,
if the author
Right.
would be interested, I'd be glad to work with you on an amendment to do that.
Of course, I'm always
Thank you.
happy to work with you.
You're recognized, Senator.
Okay.
I teleported over here and became Senator Paxton.
Thank you, Madam Chair, with your permission. Yes, certainly, I'll be happy to work with you on an amendment, but however, what this bill does is still restrict the phone from being used in the room where the voting is taking place. So that's what this bill does. It restricts that from being used wherever the vote is taking place. And in addition to that, as part of the certification process for voting machines, the Secretary of State requires the machines not to connect to the internet in order to be used. And so these machines are not connected to the internet when they're used for voting. We have that from the Secretary of State's office, and we do have a resource witness.
Well, and I was just notified that we have someone here from the Secretary of State's office as a resource. Ryan Jimenez. Chair calls Ryan Jimenez from the Secretary of State's office. Thanks for being here. And if,
I mean, given the Bluetooth distance, Senator Zaffarini, depending on the power and the intensity, you can still be out of the room and still have access.
Well, let's hear from the
That's the 100-foot thing. I would actually encourage increasing the 100-foot to about
Thank you.
200 feet.
And we did hear your testimony already, so now we'd like to hear from the resource witness. Thank
all
you.
right, does someone have a question for the Secretary of State's
Yes.
witness, Ryan Jimenez? Senator Zaffarini, you're recognized.
Yes, could you please clarify this misunderstanding?
Yeah, so I can't get into the specifics because I'm not too familiar with the certification. I can tell you though that, these systems are required to be in compliance with federal and state law. They go through rigorous testing to ensure that unauthorized access can't be granted.
So your testimony is that the Bluetooth that is in use by this, by the polling equipment is something that can't be accessed by unauthorized?
Yeah, that's what, like I said, that's what federal and state law requires, is that they can't be accessed by unauthorized means. And so that's when these machines get certified by our office, meaning that they pass the certification and they meet the qualifications set out by law.
Senator Hall?
There's a big gap between what the law says and what reality is and what's existed. We have it all over the place. You're not supposed to be able to use skimmers on gasoline pumps, but they do the same thing. And we know, we have hard evidence of video seeing our poll books being accessed improperly. They have to be tied to the internet, or they can't be used for what they're being used for because they're in the county-wide voting location. So you have to have them connected to it. And the law can say all it wants to about not being able to do it, but we have a lot of criminals in this country that ignore the law when they want to do something. So to say the law doesn't allow it has nothing to do with the reality of what actually happens. And that happens all over the place in here, and it is a real problem that does need to be addressed.
Thank you, Senator Hall. Senator Zaffarini, did you have any?
Yes, for the resource witness. Is there anything else that you would like to say about this bill?
Nothing that I could add that hasn't been said already. Like you said, there's still the requirement that phones aren't used in the room that the voting is taking place. Other than that, if there's any amendment or any further discussions, our office is happy to work with any of y'all to answer any questions.
Thank you so much. And I look forward to working with Senator Hall, and we'll call on you too. Thank you. Thank you, Madam Chair.
Thank you. Thank you, Senator. All right, Dr. Presley, Mr. Jimenez, thank you for being here. You're our invited testimony. We'll appreciate your testimony, and you're dismissed. Thank you. So we'll close invited testimony.
Hey, ma'am.
Sir,
you
hold on
invited me
just a second. You're not invited testimony, so we're about to open public testimony. If you don't mind holding for just a second.
I was invited up.
Your public testimony.
So the chair closes invited testimony and opens public testimony. We do not have anyone registered to testify on this bill. Sir, did you register to?
I can't remember if I did this one or not, but when the chairman invited people up that wanted to testify, I spent 5 years in the Air Force and the Pentagon.
All right.
Experience of this stuff.
All right, so could you state your name, sir?
Yes, ma'am. David Carter. David Carter.
All right, do we have a card?
I'm registered on a different bill.
Okay.
It'll be heard later.
Okay. So, sir, if you, we'll go on and hear your testimony in just a second, but if you will please just get settled up with our clerk over here so we have all of your information on this bill.
You want me to go out to the kiosk and register?
No, it's okay. We'll have you give your testimony now.
Okay.
And then, but when you finish, if you'll just head over here to the clerk and they'll get everything. So the chair opens public testimony. And Mr. Carter, if you would state your name, your position on the bill, and then give us your testimony, and you have 2 minutes. Thank you.
Okay, thank you, ma'am. David Carter. I'm against the bill. My experience in the Air Force, I spent 34 years, and 5 of it was in the Pentagon. I've been in secure facilities with the little red lights up there, checking for, making sure we weren't broadcasting stuff out to the Russian spies. And this is right in that same thing. And I think that at this point, the recommendation was that you hold the bill up until there's further discussion and work done on it. So caution, you've seen the signs, caution, proceed with care. And this is very important. We should proceed with care on this. This is too early. I'm an election judge also up in Temple, Bell County. And my polling place is an extension of the church building. And we're right there next to the wall, and the parking places are right on the other side of the wall. And so people can, malactors can sit out there and accident, whatever they're able to figure out how to do, which we don't know enough to write a bill to cover that, I don't think. But it was very dangerous to have, I don't even know why the Bluetooth is there, because when I set up my polling place, it was with cables to the printers. There was no Bluetooth. That's a new thing, and it's careless to introduce Bluetooth into the polling places. There shouldn't be any Bluetooth.
Thank you. Thank you.
I'll go over here and register.
I appreciate it. Hold on just a second. Does anyone have a question for Mr. Carter? All right. Thank you, Mr. Carter. And yes, if you'll
Thank you for
head
your
over there.
Thank you for your courtesy.
Thank you.
Madam Chair.
Yes, ma'am.
And to set the record straight, Dr. Presley was not invited.
Yes, I'm about to, I just realized that. So I came in kind of midstream on that particular bill. So to make a correction, we were hearing public testimony with Dr. Presley, and we called the Secretary of State's witness up as a resource witness during public testimony. Mr. Carter is also public testimony. So is there anyone else wishing to testify on, for, or against House Bill 3909? Hearing, seeing none, public testimony is now closed, and the bill will be left pending, subject to the call of the chair.
Thank you, Madam Chair and members.
The chair lays out House Bill 796 by Representative Bell over in the House, and recognizes Senator Hall, the Senate sponsor, to explain the bill. Senator Hall, I see that there is a committee substitute.
Yes, and I'll be laying out the
All right,
committee
Chair,
substitute.
send up the committee substitute to House Bill 796 and recognizes Senator Hall to explain the difference.
Thank you, Madam Chair and members. The principles of state sovereignty are established in Article 1 of the Texas Constitution and the 10th Amendment of the U.S. Constitution, which reserves all powers not explicitly granted to the federal government to the states or the people. This principle stems from the early American understanding that all political power is inherent in the people, and all free governments are founded on their authority and instituted for their benefits. After gaining independence from Mexico in 1836, Texas retained its status as an independent republic before joining the United States in 1845. When the Founding Fathers of Texas created the state, they established a constitution to preserve and protect the power of the state, which is nothing more than the combined authority of its citizens to create local systems of governments and collectively with other states to establish United States. It is the duty of the state to protect and preserve the liberty and rights of its citizens from other branches of government, local or federal. Recently, concerns over federal overreach have prompted calls for Texas to exercise its sovereignty. To safeguard its rights to self-government, Texas should establish a mechanism to identify and challenge unconstitutional federal actions, ensuring they cannot be enforced within the state except by federal law enforcement. Federal law can only legitimately set regulations in line with the authority granted to it. All other rights are retained by the state or the people, and we do not expand our rights through sovereignty, we exercise them. The committee substitute for HB 796 would establish a permanent joint legislative committee on constitutional enforcement. The committee's purpose is twofold: to review federal actions that may affect Texas sovereignty and determine whether those actions are unconstitutional. The Joint Committee would consist of 12 members, 6 House members appointed by the Speaker, and 6 Senate members appointed by the Lieutenant Governor. No more than 4 members from each chamber may belong to the same political party, ensuring bipartisan representation. Each presiding officer would designate 1 joint chair, and members would serve a 2-year term aligned with the regular session calendar. When the committee determines that a federal action is unconstitutional, the process unfolds in 3 stages. The committee reports its findings during the current or next legislative session. Both the House and the Senate would vote by majority to adopt the committee's finding via a concurrent resolution, and the resolution is sent to the governor for approval or disapproval. If the governor approves the resolution or does not object, the state formally declares the federal action to be unconstitutional. What happens next is the unconstitutional action that has no legal effect in Texas. No public money or resources may be used or implemented to enforce it. State law enforcement may arrest and prosecute federal agents attempting to enforce such actions under the Texas Official Repression Act, and the Texas Attorney General is authorized to take legal action to prevent enforcement, and the Secretary of State will notify federal officials and the Texas congressional delegation. Committee substitute for HB 96 broadens the review of scope by using federal action instead of directives. It also adds requirements to the concurrent resolution, such as allowing repeal of a declaration by a 2/3 vote of both chambers, and the committee substitute removes the 2/3 threshold for initial adoption of the concurrent resolution because of the comprehensive activity by the Joint Committee, simplifying legislative action. Chairman, members, the Texas Sovereignty Act is grounded in constitutional principles, particularly the 10th Amendment, and reflects a clear legislative path for the state to defend its constitutional boundaries when federal actions stray beyond them. With that, be happy to take any questions.
Thank you, Senator Hall. Members, are there any questions for the author of the bill? For some reason, my eyes went straight to you, Senator Birdwell. All right, you're recognized to ask the author some questions.
All right. Thank you, Senator Hall. Thank you, Madam Chair. Senator, I want to have a conversation with you here in some granularity, if I may. In page 6, line 22, section 394.003, committee review of federal action, subsection C. When reviewing a federal action, the committee shall consider the plain reading and reasoning of the text of the United States Constitution and the understood definitions at the time of the framing and construction of the Constitution by our forefathers before making a final declaration of constitutionality. And then it gives the 3 subsets in relationship to ratifying debates, understanding the leading participants in the convention, and then the doctrine in question by the constructions of the several states. Does your bill contemplate the Constitution as ratified, including the amendments currently in place as ratified?
That's my understanding. The Constitution as we currently have it.
Okay. So that means you would need to include something that says say for the Civil War amendments, the amendments since the Civil War that deal with the founders, or not the founders or the forefathers, but the ratification debates or the proposal debates in the Congress for sending those to the states.
Okay. Yes.
Meaning the founding fathers didn't have a discussion about the 17th Amendment. The founding fathers didn't have a discussion about the 18th Amendment. Founding fathers didn't have a discussion about the amendments beyond there were certainly discussions about the slavery question, but they didn't have discussions about the 13th through the 28th Amendment.
Okay.
So what I'm trying to make sure of is that it's the Constitution as it is, not just the Constitution as it was in 1789.
No, as it is, it's not trying to go back and rework our Constitution. It's take a look at what we're.
No, I know it's not reworking. What I'm saying is the way this reads, that committee contemplates what the founders said, but there are portions of the Constitution that were not reviewed by our founders because it has been amended since the founding generation.
Right. Back to what line in particular are you looking at there?
Lines 22 through 27, page 6. So the understood definitions at the time of the framing and construction of the Constitution by our forefathers. The Constitution's been amended since the forefathers. And in fact, the first Bill of Rights, the Bill of Rights were actually amendments to the Constitution after its ratification.
The intent here, as I understand, is to look at current new federal actions and determine whether they are considered to be constitutional or not going back and re-evaluating, relitigating previous amendments.
Okay. But whether it's the amendments or regulation, in my capacity as Chair of Natural Resources, Senator Perry in the same vein, Water and Ag, we deal with a number of things related to EPA. Each of our committees deals with, I'll use the military term, battle space that the states have is to make state policy within the confines of federal policy. So it isn't simply the amendments that we're dealing with, it's also either federal statute or regulations that have not been invalidated by the Congress. We deal with those as well. But many of those were after the founding period. That's why I asked the question. Because if you go back to 1787 to the ratification in 1789, I'm trying to make sure that we're contemplating everything in between.
Okay.
Because if we're not, I think there's already a significant challenge with this, but if we're not, that's an even larger challenge.
No, there's no intention to go back and do that. And if you think there's paragraph 8 that we need to add to clarify that, I'd certainly be open to discuss that because it's intended to address this going forward.
Okay. Let me ask some other, I appreciate your answer, Senator. Let me ask, it says here that a majority of the members of the committee constitutes a quorum. Page 6, just above what we were just looking at. Letter H, line 15. Given that the body that you're contemplating creating here is evenly split between the House and Senate, and that you could, and because a meeting can be called by either joint chair, the bill contemplates the possibility, not necessarily the probability, but the possibility that you could have 6 members from one body, 1 member from the other body, which is a simple majority for the quorum, and therefore you could have one body vote in either favor or disagreement on something. Would it be better to have something that relates to a subquorum where you've got a quorum of each body present, so that instead of 6 members from the House and 1 senator, now is a functioning quorum, and you don't get the dynamics of both bodies? Would it be better to have, you must have 4 members from each body to have a quorum, recognizing that that might mean the one body says, we're not just not going to show up. We've dealt with that a couple of sessions back where the Senate was functioning and the House wasn't. But I'm just concerned that the way it's structured could lead to a circumstance where one body dominates the other rather than acting in unison.
I understand that, but again, the unintended consequences possibly of trying to solve that would put us in a position like we've seen when some members of this disappeared to New Mexico to keep things from happening.
Yeah.
And so the solution may be more detrimental than the potential, the possible problem.
Okay.
Again, on this, if you have some thoughts that would recognize that, I'll be glad to discuss them with you.
Okay. Well, I do. I mean, we sent Senate Bill 707 out of here, which was, I thought, a very tight shot group on, because I clearly agree with your sentiment. I mean, everything from, Marbury versus Madison. I mean, we can go down the list of court decisions. We can go down the list of the number of things that the federal government treats the states as nothing more than subcontractors to federal will. Now, I get the sentiment, agree with it, but I want to make sure we're acting constitutionally with the authorities that the state has.
And
I'm not so sure that's happening here.
Okay.
So go ahead, I'm sorry.
No, I'm sorry, and I agree with that.
Yeah.
And so I welcome your wisdom, because I know the amount of background that you have in the subject. Because there are the other things that the bill requires, which I think are certainly appropriate. Page 7, line 13, the statements of support for natural law, natural rights by the framers and philosophers admired by the framers. Would the state contemplate, who gets to, how do I say this? Of those 12 members of the committee, who gets to decide which framers and which philosophers? Because whether it's John Locke, Montesquieu, the Bible's actually the most quoted document of our founders in establishing our Constitution. Locke's treatise of government, his 2 treatises of government. I'm just trying to think of I don't know that I want a certifying official. I'm just trying to think of who's the certifying official that decides which philosophers we're going to pay attention to in this 12-man committee, or 12-man or woman committee, I should say. I think that'll be decided by the body as a vote, because there will be those that will have an opinion of Locke in some cases and not Locke in the other cases.
The body of 12 or the body of 150 and a body of 31?
Both, whenever the time comes for vote.
Okay.
The idea was to keep it in the context of what was intended, and a lot of that were the parameters that were contended, but not everybody agreed completely with everyone.
Okay. Let me move to page 9, because I've never seen this before. Page 9, line 8, subsection F, it says, the legislature may repeal a concurrent resolution adopted under this section only by concurrent resolution adopted by a vote of 2/3 of the members present in each house. In 2017, when I had the bill that rescinded all of our previous calls for an Article 5 convention except the balanced budget amendment, it takes a simple majority to send that resolution. It took a simple majority to send those resolutions. It took a simple majority to decertify them. I've never seen anything where you can get into something by a minority, but you have to have a supermajority to get out of it. When we send constitutional amendments to the people of Texas, both bodies have to vote for it by 2/3, but the people only have to ratify that by 50% plus one. In this case, the legislature could certify by a simple majority, but not decertify by a simple majority. How did you contemplate a supermajority for rescission with only a simple majority for adoption?
I think behind that was to try to get away from a yo-yo back and forth easily, that once something's adopted, it would be more difficult to move away from it.
Well, and that's always been the case. I mean, look at what's called Obamacare. You know,
Yeah.
once you're into something, I mean, the only place in the U.S. Constitution where you see that is the adoption of prohibition and the repeal of prohibition. That's the proper way to do it, because to do both those amendments took the proper procedure for the Congress to send to the states, ratification by the number of states required, and it was done. When Senator King had 707 in front of us, he had 2/3 in one body, but only a simple majority in the other. And he took my amendment to make it 2/3 in both bodies. If the adoption is by a majority, then I think the rescission should be by a majority. If the adoption is by a supermajority, the rescission should be by a supermajority. But I've never seen anywhere adoption by majority, rescission by supermajority. I've seen that in no, and I don't think that's a precedent we want to set.
Okay. And I don't think that's a hard one here. Certainly would be glad to work with you on that issue.
Here's the most difficult question, and that is particularly what the bill does with our courts. Same page, line 11, other determinations of unconstitutional federal acts. And it says the chapter does not limit or alter the authority of the governor, attorney general, statewide elected officials, state or federal court, judge or justice, a state or local appointed or elected official, or the governing body of a political subdivision of this state to issue a verbal or written opinion determining a federal action to be unconstitutional. Where does a state court draw the authority to determine the constitutionality of a federal procedure?
I don't think it was intended to be just telling the courts, this is not changing their ability to do anything they're already capable of doing.
Well, the state courts are capable of deciding state cases, but giving a state court the ability to determine a federal question of unconstitutionality, I think we put our state courts in a very, very difficult position, particularly when well, let me go to it here real quick. On page 11, line 18, section E, or subsection E, it says section 37008 does not apply to relief sought under this section. And when you go read that section, that's the section that says the court basically is a mandamus order in the bill on the court that says a court must render a decision. So the bill compels a court to make a decision that I don't think it has the constitutional authority to decide over federal action. So I think we put our judicial branch in a very untenable position the way this is structured. My preference would be 707 was a very tight shot group that Senator King put together. Didn't go beyond the left and right, first and third base foul lines of what the state is authorized to do. I want to hear the testimony. I very much share your sentiment. When at the end of the not the Biden administration, end of the Obama administration, Governor Patrick is exactly right. Secretary Duncan had sent the letter, what we called the Secretary of Education under President Obama, the Dear Colleague letter that said, states, you won't get your school lunch money unless you let little Johnny share little Joni's shower. You remember that? We were all,
Yes. Yeah.
and Governor Patrick, had President Trump not won, Governor Patrick was ready to remove the state from accepting those dollars and then have the state backfill them. We were looking at those.
Right.
I very much agree with your sentiments and concerns, but I think I certainly want to hear the testimony, but and I'm not picking on you here, but there's an expressed, and I don't want to relitigate it, but there's an expressed method in the Constitution for the states to gain control of the federal government that they created, and that's an Article 5 convention. This, I think, will create more confusion, particularly in the judicial branch. I agree with the sentiment. I just don't understand how this can, how do I say it, functionally operate without the conflicts that will arise on those things that are a federal responsibility versus are not a federal responsibility, and under whose determination and judgment of what is constitutional and what's not constitutional. And then compelling the courts to have to rule on things. And then you also, in the bill, you give all of the courts of the state original jurisdiction. In my emergency and disaster power bill that you supported every time that I gave the Supreme Court original jurisdiction for a lawmaker to go to the Supreme Court, giving every court in the state jurisdiction would include the 15 appellate courts. There are places in state law that the appellate courts are the finder of fact, not many, but I had to deal with one of those when, as it relates to residency as a candidate. But I don't see how you can make this tenable for the judicial branch. I'd really rather see 707, which is what we did, because I think that is a tighter shot group, doesn't cause the confusion, allows the state to not participate, but not go beyond the non-participation and compel actions that may get our judicial branch officers in difficulty, may get legislators in difficulty. I clearly agree with the ability to send a resolution to Washington, not that they pay much attention to those, but I'm concerned for the practical application of how this is written. And 707, I think, was a much tighter shot group. I agree with your sentiment. There's much in here to be applauded. Much of 707 is in here.
Yeah, it is. 707 was rolled into this committee substitute. And I'll be glad to work with you on this, because the idea here was the Article 5 convention. That takes the other folks. This puts us in a position, we don't have to wait for them. We have something, an issue that needs to be settled for Texas. Then we did something, a version of this.
Then I'd rather, we may have to go down a subject here, revisit a subject that isn't fun to revisit here in the chamber. Then I'd rather have the ability to do a resolution that compels the Attorney General. If the Attorney General, right now, and previous Attorney Generals have all been more than willing to go to federal court, seek relief based upon a constitutional analysis. The day we don't have an Attorney General that does that, I'd rather see the legislature be able to tell the Attorney General, we want you to do this. Maybe that's the place for the, because that's his proper role, to protect the state. And if the Attorney General does not have the capacity or the will to protect the state as the legislature desires, again, I'm going to bring up the I word, but at some point, does the legislature say, thank you for your service, Mr. Attorney General, you're removed from office because we want somebody that'll do this?
Well, that's,
So once you go down the road of, I mean, when you had in here, let me find it real quick. I'm looking for the right page. I beg your forgiveness here, Senator. You list every possible state actor, governor, lieutenant governor, statewide elected officials, school districts, charter districts, every geopolitical subdivision of the state. Every officer is compelled to act, and if in their judgment they act and the legislature disagrees with that judgment, they may be at risk. If they don't act and the legislature is in disagreement with their inaction, you place every geopolitical subdivision officer of the state in a very difficult position, in the same way that I think the judicial branch is placed in a very difficult position.
but that's no different than any law we pass.
But the laws that we pass are based upon the authority of the state over state officers, as opposed to the interpretation of each individual,
Okay, but that's
each
what we're
individual
saying
office
here
holder of what is what is federally constitutional and what is not federally constitutional.
Okay.
I would rather see the Attorney General be that person, because one, that's been most functional for us, but two, it doesn't place every state actor across all 254 counties, all 1,200 school districts, every river authority, every geopolitical subdivision that we have created, place them in the subjective state of what do I do if the legislature doesn't agree with my action or my inaction.
Just like any other law, because we're not talking about changing the Constitution. We're talking about saying the federal government's taking an action that we feel is unconstitutional, and therefore, we're not going to have that implemented in Texas. That's no different than any other law we had passed to say we're going to do it this way. We're not changing it. We're just telling, hey, federal government, you have overstepped your bounds, and we're not going to. We did this when we passed the Second Amendment Sovereignty Act a couple of sessions ago. They said, federal government, you're not going. You can pass all the new gun laws you want.
And we said we wouldn't. And we said we would not participate. And that was as far as we went. And that's where 707 ends. We won't participate, but we will not go beyond that. So I agree with the sentiment profoundly. I'm not sure that the methodology is the right methodology. I'll leave it at that, because I have immense respect for you, Senator. I just, I'm trying to think through. It's one thing for Texas to pass laws that apply to Texas, but the subjective nature of deciding that the state or state actors are compelled to decide what is constitutional or not constitutional may place those individuals. It's part of the reason why I voted the way I did on the last version of our border security bill last session, because it may place law enforcement, school board members in a very difficult circumstance that, as much as I applaud trying to get the federal government back in its 9th and 10th Amendment box, the people most responsible for that are the citizens. In your layout, you talked about how citizens were the sovereign embodiment of the state. They're also the sovereign embodiment of the federal government. The same citizens that vote for our congressional delegation are the same citizens that vote for our state officers. I'd much rather see us contemplate something for the Attorney General if the Attorney General refuses to act. I very much appreciate the conversation. I'm sorry I've dominated it, Madam Chair.
It's all right. And we want everybody to get their questions asked and answered.
Okay, if you're done, let me just
Yeah,
this would, a good example would be, there's a lot of stuff that the federal government now tells us to do, and they hand us money. And we say, you have no business telling us to do that. We're not going to give you the money unless you do this. So you have a situation that said, we're going to tell you to do this, but we're not going to give you the money. So we would want, and I would see our reaction to that to be no different than if we created a new law that the body agreed to, the governor signed off on it. Every city, county, judge, school district, everybody else is going to have to obey that law because we decided it. I'm not talking about going out and doing a challenge on the basic tenets of the constitutionality. I'm talking about the situation we have here where we have a federal government that loves to tell the states what to do outside of their authority to do it, and then they bribe us to do it.
You've just made a great case about the problem with the 17th Amendment.
So, all right, I'll be glad to work with you to see if we can't do this, because I think we need a version of this, and if we got to make some tweaks to it, I'm happy to work with you on it.
Thank you, Senator.
Because I really respect your understanding.
And I very much
of the Constitution.
appreciate the dialogue that we've had here. Thank you, Madam Chair, for your discretion and grace.
Thank you, senators, for your thoughtful discussion. Any other questions for the bill sponsor, Senator Hall? All right, then we will move on. The chair opens public testimony and calls John Van Compernoll, Stephen DeLine, David Carter, Tom Glass, and Austin Hounsel. If you'll just make your way down to the table. John Van Compernoll, Stephen DeLine, David Carter, Tom Glass, Austin Hounsel. And we still have 2 spots. I'm going to go in and call a couple more witnesses. Donald Gamblin, Sabina Savalyeva, apologies. Philip Leach. Hallie Sayer. All right. If I did call your name, we'll go in and begin our public testimony. Go on and come down, and we've got 2 other spots if I did call your name, and you can take a seat at either of those. But let's go in and begin our public testimony. If you would begin by stating your name, your position on the bill, and then give us your testimony, and we have 2 minutes for each person. So thank you for being here.
Thank you. My name is John Van Compernoll. I'm here testifying for the bill. I'm going to run through a quick history. In the late 50s, there was a series of court cases dealing with redistricting around the Voting Rights Act that ultimately came for 1965. The result of those court cases was that Texas and 14 other states had to have their redistricting approved by the Department of Justice. In 2013, that was found to be unconstitutional. So this last redistricting is the first one that wasn't under the thumb of federal oversight. The thing that most people understand that. I think the thing that people miss is that by 1969, 33 states had applied for an Article 5 convention for the specific purpose of saying the federal government had no authority, a clarifying amendment. The 34th state would have been Wisconsin, and it failed narrowly in their Senate. That would have given us an Article 5 convention to propose a clarifying amendment. 2 weeks ago, I testified in our Article 5 resolution saying that Texas should use every part of its power to resist federal overreach. So I don't know that this bill is perfect, and I haven't seen one yet that is, so we'll assume it's not, but it is something that Texas has to do. Since the 1960s, our federal government has gone way, way, way outside of their authority, and we need to do everything in our power to rein in that authority. So whether it's this bill, but this bill and the results of what this commission finds as unconstitutional could clearly feed a limiting Article 5 convention and set us up for victories against the federal overreach. Thank you.
Thank you for your testimony. And members, if you don't mind, we'll wait till everyone testifies and then ask questions. Thanks for being here. Please give us your name, your position on the bill, and then we look forward to hearing your testimony.
Thank you. Tom Glass, with Texas Constitutional Enforcement. We're in favor of the bill. In fact, I and our organization helped write it in the early days. The main thing that I'm trying to do with helping write this bill and pushing for this bill is to make sure Texans stay free. And that we have a systemized, organized way to push back on the federal government when it goes too far. And it flows from my understanding of Article 6 of the Constitution, which has two important parts. The second part of it, but I'll talk about it first, is it requires every person in the government, including our military and our law enforcement, to swear an oath to preserve, protect, and defend that Constitution. And the other part of Article 6 says the Constitution is supreme and laws in pursuance thereof are supreme. That supremacy clause begs the question is who decides what's constitutional, what's in pursuance thereof? And the framers were pretty clear on this. Madison and Jefferson in particular said that to expect one part of an agent, of a group of people who are delegated power to determine the limits of their own power, it doesn't make any sense. You don't have an employee and they get to make their job description. And I really appreciate the fact that Senator Hall started off with Article 1, Section 2 of the Texas Bill of Rights. It's engraved on the Zavala Library. All political powers inherent in the people. The Declaration said, consent of the governed. The preamble of the Constitution says, we, the people of the United States. So who's the boss around here? It's we, the people. Whoever makes the final decision is ultimately the boss. Okay, we're out of time. I have a whole bunch of answers to the questions you were asking. If you would like to ask me, Senator Birdwell, I have opinions on a whole bunch of what you were talking about.
Thank you, Mr. Glass. Appreciate your testimony. Mr. Carter, if you would state your name, your position on the bill, and then give us your testimony, please.
Thank you very much. David Carter, in favor of the bill, and why? Because a review of our history since adoption of our Constitution shows a steady pattern of careless neglect by citizens and state governments. Unauthorized acts by the federal government, I use that instead of unconstitutional, unauthorized acts by the federal government have been passively tolerated for the most part. Why? The Declaration of Independence explains why. All experience hath shown that mankind are more disposed to suffer while evils are sufferable than to right themselves by and ... Now, doing what? Making some substantive change. The bill establishes a formal, quote, a formal substantive change. It will provide a means, if we use it adequately and with wisdom, to redress over 200 years of encroaching federal assumption of powers never delegated by the people, i.e. without consent of the governed. In the preamble to our Constitution, we the people of the United States do ordain and establish this Constitution for the United States, unquote. Therefore, we call on you, our state government, to become more observant, more perceptive, more discerning, more diligent, and put the federal horse back in its constitutionally designed corral and keep it there in the future. I call attention in my written testimony a careful collection of quotes from the founding generation who were very concerned that this newly proposed form of government would grow into another tyranny, trampling their rights. In order to persuade enough to vote for ratification, they were promised a Bill of Rights. The 9th and 10th Amendments are at the heart of the choice you are now called to make today, to vote to enforce it. The Constitution cannot enforce itself. Only living, breathing humans can enforce a contract such as this. Please do so.
Thank you. Appreciate your testimony. Members, any questions for our witnesses? All right, thank you. We appreciate you coming. You're dismissed. I'm going to give another call to the other folks we have registered. Stephen DeLine, Austin Hounsel, Donald Gamblin, Sabina Savoyeva, Philip Leach, Hallie Sire. All right. Is there anyone else wishing to testify on, for, or against House Bill 796? Hearing and seeing none, public testimony is now closed, and the bill will be left pending, subject to the call of the chair. Chair lays out House Bill 2885 by Representative Gerdes and sponsored by Senator Schwertner over here in the Senate, and recognizes Senator Birdwell to lay out the bill.
Thank you, Madam Chair. Members, this is HB 2885 is the Bastrop Mixed Beverage Election Bill. It would amend the Alcoholic Beverage Code to allow Bastrop County and the municipalities to hold elections on the sale of alcoholic beverages and implement zoning regulations of alcohol selling businesses within designated zones. These provisions would allow both the county and municipalities to ensure that businesses align with community interests, promote economic growth through responsible commercial development, and strengthen quality of life through targeted regulations. Members, Bastrop County is a growing region experiencing increasing demand for modernized local regulation pertaining to alcoholic beverage sales. Current laws require complex petition procedures that can be burdensome and time-consuming. House Bill 2885 allows the Bastrop County Commissioners Court and municipal governments to call for local option election to legalize the sale of alcoholic beverages, and it responds directly to community needs without requiring a citizen petition, and allows county and cities to be more proactive in managing local economic and regulatory issues. If I read this correctly, there are various members of the of Bastrop County elected officials that are here as resource witnesses in favor of the bill. So with that, Madam Chair.
Thank you, Senator. Appreciate you laying out this bill on behalf of Senator Schwertner. Members, any questions for Senator Birdwell on behalf of Senator Schwertner? I kind of want to think of one, but I guess I'll pass on that. All right. Not having any questions, we'll go on and move on to public testimony. The chair calls Adina Lewis and Hunter Allen, House Bill 2885. Adina Lewis and Hunter Allen. Come on down and have a seat. And if you have some papers to hand out, you can pass them right over here, and we'll get those distributed. Thank you.
Just so I'm not...
And while I'm at it, I'll go on and just ask if anyone else is here wishing to testify on, for, or against House Bill 2885, if you would make your way down. All right. Thanks for being here. If you would state your name, your position on the bill, and give us your testimony, you have 2 minutes. Thank you.
Thank you so much. Whoops. Where do I go?
There we go.
Thank you so much. My name is Adina Lewis. I'm the Director of Tourism and Economic Development for Bastrop County. This is an issue that I have been working on for a long time, trying to fix it internally within the structure that exists. The problem that we have is, in order to have someone receive a mixed beverage permit, there has to have been a qualifying election held in that governmental body. The way that it's set up right now, you must file a petition for 35% of the number of people that voted in the last gubernatorial election. So the papers that you're getting show you the numbers that we would have to get signatures for in Bastrop County to make everything equal for all property owners in Bastrop County. It would take 2,240 signatures. I'm going to tell you, in a rural area, that's very difficult to achieve. So what we're asking with this bill is to skip the petition part and let the commissioners or the city councils themselves go with the opportunity to set up an election in their area, their political subdivision. It's just an equal rights, property rights situation. We have the little map that I have also given you shows the purple area is available and qualified to get a permit. All of the white area that you see in our county, which is most of it, if someone goes to the TABC, they'll send them to the county clerk, and the county clerk will look on the map and see where the lines were drawn at the last election. In this case, in Bastrop County, it was 2005, and it was for the precinct as it sat then, in order to enable the Hyatt Lost Pines to be a full functioning resort and hotel. So anything that was not there in that precinct in 2005 does not qualify, and the county clerk then has to say, I'm sorry. We have turned away many businesses because of this. We have a case that's a veterans group, husband and wife, bought some property, wanted to do a distillery and a tasting room. They can get a permit to sell you a bottle, but they cannot get a permit to sell you an ounce.
All right, thank you. We appreciate you being here and explaining the situations. Members, any questions for the witness? Thank you. Appreciate you
carrying
coming.
it up for us.
All right, one more call for Hunter Allen or anyone else wishing to testify on, for, or against House Bill 2885. Hearing, seeing none, public testimony is now closed, and the bill will be left pending subject to the call of the chair. All right, the chair calls up, lays out House Bill 2702 and by Representative Raymond, and recognizes Senator Adam Hinojosa, this as a Senate sponsor, to explain the bill.
Thank you, Madam Chair and members. This bill is a refile from last session where it passed the House unanimously and passed the Senate with a vote of 29-2. Unfortunately, the bill was vetoed by the governor, so there has been changes made to this bill that the author feels have addressed those concerns. Veterans of Foreign Wars, or VFW posts, are a place for veterans to find hope in community, to fight against isolation and high rates of suicide. In addition, they provide intake services for other resources that the Texas Veterans Commission offers. Around 200 of these posts possess a TABC license to help pay for property and other building expenses. During the summer and fall of 2020, the majority of these posts were closed under emergency orders as TABC laws and procedures designated license holders as non-essential businesses. This was despite the fact that the primary function of a VFW post is to assist the over 68,500 Texans who have served their countries overseas. Members, House Bill 2702 amends the Emergency Management Government Code to provide an exception for 501c19 VFW posts that benefits veterans of the United States Armed Forces. These organizations are necessary and valuable and should not be subject to closure for a service irrelevant to their primary purpose. I pray that we never see another pandemic, but in the case that outside circumstances cause our veterans to become isolated, I believe it is crucial to give them all the tools they need to make it through. I've been in contact with the author and the governor's office to address the concerns regarding when a closure will be authorized, and a committee sub is in the works to limit closure to only a pandemic, maintaining the authority of the governor during other serious emergencies. And with that, Madam Chair, I'm happy to answer any questions.
Thank you, Senator Hinojosa. Members, any questions for the author? I've carried legislation in this direction before too, and I appreciate what you're doing here. Thank you. No questions for the author, and so the chair will open public testimony and calls Mitch Fuller. I know I saw you come in. You can't really sneak around very much, can you? You're just not a tiny person there. Glad you're here.
Thank you. Thank you.
Mitch. If you would please state your name, your position on the bill, and then give us your testimony.
Thank you, Madam Chairman, Senators. Mitch Fuller, Legislative Director for the VFW Department of Texas, and obviously enthusiastically support this bill. And Senator Hinojosa, thank you for carrying this. And this, like you said, this is a redo from the last session. It passed the House unanimously, 28-2. And I think that there's been coordination with the governor's office, you alluded to, about some of the language about natural disasters and all of that. Unfortunately, our VFW posts were caught up when the pandemic hit in 2020, and we were not considered an essential business. So as the senator alluded to, we have posts that have TABC licenses. That does not mean that they are bars. And that was the issue that we had. So the options that we were at, and I want to thank Senator Campbell, I want to call her out because she was very helpful in getting us in front of the TABC when that happened 5 years ago. But just because a post has a TABC license does not mean it's a bar. And we were told, we'll just become a restaurant. Well, that cost my post $3,000 to convert that license from a red license to a blue license. And that's a lot of money. My post could handle it, but that's one post that was forced to play by the rules. And now they're coordinating with 3 levels of government. So the state says you're closed. Now you got to coordinate with the county and the city. So you're coordinating with 3 levels of government. So we are not asking for anything special, but our posts, our homes for our veterans, they're a place to go, and especially in a time like that when there was so much isolation. So we appreciate the governor working with you, Senator, and Representative Raymond. Thank you.
Thank you. Members, any questions for Mr. Fuller? All right.
Thank you, Madam Chairman, Senators. Thank you.
Appreciate you being here. Is there anyone else wishing to testify on, for, or against House Bill 2702? Hearing, seeing none, the bill will be left pending, subject to the call of the chair. And public testimony is now closed. All right. Chair lays out House Bill 186 by Representative Patterson and Senate sponsor Adam Hinojosa, and recognizes the author or the Senate sponsor to explain the bill.
Thank you, Madam Chair and members. If you'll give me a little latitude on this layout. Today I speak not only as a legislator, but as a father. Like so many parents across our state, I've watched my children grow up in a world that feels less and less safe, not because of where they go physically, but because of where they go online, in spaces that my wife and I cannot possibly monitor at all times. The playground is no longer the neighborhood park for the schoolyard, or the schoolyard. It's a glowing screen, a digital landscape dominated by social media, driven by algorithms, and largely unseen by us parents. This bill, House Bill 186, is personal. It is urgent, and I hope we are not too late. Social media is no longer just a place to share photos or chat with friends. It has become a powerful, addictive force engineered to capture and keep our children's attention. These algorithms are not neutral. They're designed to exploit developing minds. They reward the most extreme content. They encourage endless scrolling. They bypass parental involvement. And they are contributing to a crisis of mental health in our youth, the likes of which we've never seen. According to the CDC, suicide is now the second leading cause of death for children and young adults aged 10 to 24. Our kids are dying. The data shows that these tragedies do not occur in a vacuum. They are closely tied to the rise the pervasiveness of social media. A 2023 report from the Surgeon General warned that excessive social media use is fueling sharp increases in anxiety, depression, and body dysmorphia, particularly among teenage girls. We see the impact every day. Young people comparing themselves to edited, filtered versions of others, constantly measuring their self-worth against impossible standards. We see kids retreat into isolation, chasing approval through likes and follows, while their mental health collapses behind the screen. They're in the most vulnerable stage of their life, puberty, when emotions are high, identities are still forming, and insecurities are at their peak. And in this fragile state, they're being fed a steady diet of confusion, shame, and manufactured inadequacy. Worse yet, social media platforms are not just exposing children to unhealthy content, they're leaving them open to predators. These are grown adults hiding behind fake accounts, private messaging, and grooming children with parents never even knowing. They use the very tools these platforms provide, anonymity, encryption, and false trust, to prey on kids who don't yet have the tools to recognize this danger. This isn't a hypothetical. These stories are real. They're heartbreaking. NBC News reported on a 14-year-old girl in Wisconsin who died attempting the blackout challenge, a viral trend where children intentionally choke themselves to the brink of unconsciousness. ABC News told the story of a 13-year-old Ohio boy who overdosed on Benadryl after trying the so-called Benadryl challenge he saw on TikTok. These aren't isolated tragedies. They are symptoms of a system that profits while our children suffer. Right here in Texas, the Houston Chronicle exposed cases where predators use platforms like Snapchat and Instagram to target, manipulate, and abuse children, all without a parent ever seeing a warning sign until it was too late. House Bill 186 draws a line. It says enough is enough. And this does not even begin to detail the amount of cyberbullying, death threats, abuse, and other harmful content and messages sent by peers. This bill will require social media companies use a commercially reasonable method that relies on public or private transactional data to verify an individual's age. No child under the age of 18 will be allowed to open an account. The information provided must be used solely for verification and cannot be sold, stored, or used for any other purpose. No child will be allowed to wander blindly into the darkest corners of social media while their parents are kept in the dark. Any social media company that refuses to comply with this bill and is found to be allowing children to open and operate accounts will be subject to action by the Consumer Protection Division of the Attorney General as a deceptive trade practice. Let me be clear. This is not about censorship or overreach. This is about protecting children and recognizing that they should not be treated as data points or revenue streams. They are not customers. They are our children, our grandchildren, and we must protect them. We have the ability and the power to act. Today, with House Bill 186, we confront the evil before us and boldly say, you cannot have our children. I urge you, members, your support as lawmakers, as parents, as grandparents, as mentors, and as protectors of our children and our future generations of Texas. With that, Mr. Chairman, I yield for questions.
Thank you, Senator. Thank you for that. Senator Paxton, you're recognized.
Thank you, Mr. Chairman. Thank you, Senator Hinojosa, for your layout on this bill. And I have developed a deep appreciation for your authentic, heartfelt concern for our children as a parent yourself, but extending to all of the children in Texas. And you've worked with me on legislation that has been directed toward those kinds of issues, and I appreciate that, and just want to commend you for that.
Thank you.
And I know you were an author on the App Store Accountability Act with me that we just passed and has now gone to the governor's desk, passing the House and the Senate. to require parental consent from app stores and apps themselves to make sure that parents know what their children are looking at and that they affirmatively choose to authorize that or not.
Right.
And so I'm interested. I think these two bills, this bill and my bill, the App Store Accountability Act, have a lot in common. Certainly in intent, but also in mechanisms as well. I wondered, so for this bill, how is social media defined in the bill as opposed to just any app?
Thank you for that question, and thank you, Madam Vice Chair, for your commitment to protecting children. The definition of social media is social media platform means an internet website or application that is open to the public, allows a user to create an account, and enables the user to communicate with other users for the primary purpose of posting information, comments, messages, or images. The term does not include an internet service provider as defined by section 324.055. It does not include electronic mail or an online service application or website that consists primarily of news, sports, entertainment, or other information or content that is not user-generated but is pre-selected by the provider. And lastly, for which any chat, comments, or interactive functionality is incidental to, directly related to, or dependent on the provision of the content described by paragraph chapter 120 of the Business and Commerce Code as an applicability clause that further stipulates that a social media platform must have 50 million active users in the United States. So it just very simply, it's an app or website, allows you to create an account, make posts that are publicly viewable, send messages or make comments that are viewable by other account holders, and the curation of the content on the app or website is not pre-selected, then it is a social media company.
Well, thank you. So I think we all know there's some apps that are sort of unidirectional in the way they're used, but specifically a social media platform, as it's defined in the bill, is going to be something that's facilitating interaction between users, allowing for posting and responses to that. You know, I know in 2009, I think it was, Facebook created or launched the like feature. And you can track, we can go back and track anxiety levels among teens and depression escalating from that time. That like feature is what created the addiction mechanism and creates the dopamine hits. And there are other things as well, but that like feature, and it's that interaction. So I think, to be clear, what the App Store Accountability Act already is going to do with social media is going to be requiring a parent to approve or deny a child's access to that. But what this bill would do is it requires verification of the age, which is not hard. They already do this. And so it will require verification of the age. And if the user is a child, they cannot create an account, and they cannot engage in that. If I'm hearing you correct,
That is absolutely correct.
we're talking about those engagement platforms, social media platforms, TikTok, Instagram, Snapchat, Facebook, et cetera.
Right, and as we addressed here in the definition, I know it's kind of a long-winded answer, but it does have a carve-out for gaming, that type of activity. But as we described social media, you are correct in your analysis of
what is the carve-out for gaming? Because there's that facet of gaming is incredibly powerful in engaging users, for sure. And I know I have talked to a lot of parents that have been shocked at some of the interactions they've observed or discovered from their children in using gaming platforms.
Right, and excuse me one second. Just verifying to make sure that that was actually was included in the bill. That was a provision we were toying with as well. I think this is a starting point, with social media platforms. And again, we're making something news, sports, entertainment, other information, other content that is not user generated, but is pre-selected by the provider is not included in the bill.
Thank you for answering my questions. And thank you, Mr. Chairman, for the long leash on that. And thanks again for, I appreciate everyone's attention to what is happening with our kids. It's not imaginary, it's real. It has real impact in sometimes even in a life or death sort of way. So I look forward to hearing the testimony today, and thank you for bringing this bill before the body.
You bet, and thank you for your questions. We are going to have some invited testimony that will go over data on impacts, real impacts. We even probably have some additional stories, but you'll get to hear from others who will testify soon.
Thank you, Senator Paxton. Senator Hinojosa, members, any other questions for the author on House Bill 186? So we have 2 invited witnesses, and of course they're given 5 minutes each. That's without questions. So if there are no objections, it's my inclination for us to pause here, and when we resume after session to start with the invited witnesses. Senator, unless you want us to do, it's important we do them now or one of them now. I think that'd be my vote. Is that okay with you?
Great. Thank you, Chairman. Yeah, that would be absolutely great.
Members, that's right. So we'll be nice and clean after that layout is a good place to stop for now. And we'll come back after session and we'll begin with invited testimony on this bill and move through the remainder of our agenda. And I thank each member and your staffs and our excellent committee staff and the Senate folks to keep us operating, and every witness on, for, and against. And so if there's no other business, Committee on State Affairs stands in recess, and we will be coming back upon adjournment or final recess of the Senate today. Good morning.